Now, it may not be what many of us want to hear, but we're set for another referendum in 2014, this time for the purposes of introducing a specialised family court. Despite the Law Reform Commission stating in 1996 that such an amendment would be over-ambitious, the system has been achieved and operates in Australia and New Zealand. But what will it mean for families attending the courts, and if passed, will it result in a speedier, more humane judicial system? To discuss this in more detail and to answer some of your family law related questions, I'm joined by a solicitor from Madigan Solicitors and Mediators, Josepha Madigan. Josepha, good afternoon.
Good afternoon, Pat.
Now, first of all, what would the new court, if they were to have a referendum and were it to pass, what would be different about it and the current family courts?
What would be different, Pat, I suppose if we put in context against what's already in existence. And what is already in existence is a district court, a circuit court and a high court, which is a general court for all sorts of law. So this would be a specialised family court, and in a sense, I think, as far as I'm aware, what the Minister is hoping that this would be more humane. It would have in-court mediation facilities, there would be welfare assessment in situ. Hopefully it'll tackle some of the delays that are there and some of the costs for people.
Why would it need a referendum, do you think? Is it another layer, like when we recently had the referendum about bringing in an appeal court for civil cases so that everything wouldn't end up in the Supreme Court? Is it the same kind of thing that the Constitution has written it large, that there is no unique autonomous children's court or family court, and you have to do it then?
Yes, I mean, some people would argue that there's no necessity for a referendum. My understanding from Article 34 of the Constitution is that this deals with the structure of the courts and that we will need a referendum. And it is something that I think it needs to be put to the public, and I think most people will be supportive of it.
Delays, that's one of the things that people talk about. I mean, a new family court, it just depends on how well it's staffed, or if the delays will be back in the system again.
Well, that's it. And, you know, I think the approach that it's hoped that would happen will be that there will be a lower court and a higher court. And the lower court would deal with the current sort of district court issues and childcare issues. And the second court would have an unlimited jurisdiction and deal with more complex issues.
Like what?
Well, divorces and separations, child abduction, adoption, all of those sort of issues. So I think
so there'd be a kind of a lower processing court if someone wasn't paying their maintenance. That's where you'd end up.
Exactly, because at the moment there are horrific delays. I mean, the process for lay litigants in particular, as well as litigants who are represented, is really harrowing, and there's no other word to describe it. Really. It's through no fault, I believe, of the lawyers or the people that are involved. It's just the way the system is, Pat. And we need to this isn't reinventing the wheel. This is something that is already in place, as you said quite rightly, in other jurisdictions, where, you know, mediation, for example, is the primary way of resolving disputes, and litigation is relegated to the second option.
So it's only when everything else has failed, literally, but you're forced to go through the mediation process before you can get access to the judge.
Before you can issue proceedings, for example, in Australia, you have to engage in mediation. Now, obviously, mediation in of itself is a voluntary option, so you can't actually force people to participate in it. You can force them, however.
But the judge can say, hang on, you're not getting in here until you've made some sort of an effort to sort this out yourselves.
Yes, there are what you call mandatory mediation information meetings, and I believe now we're also going to have the mediation bill coming in next year, hopefully, which will deal with that here, where for the first time barristers and solicitors will have a statutory obligation to advise in relation to mediation. So they're all very positive.
Rather than and that applies to all sorts of cases, not just to family cases. We talked before on radio about collaborative law.
Yes.
Now, just remind people of what collaborative law is.
Collaborative law is, I suppose, in a sense, it's a less well-known primary dispute resolution process. And in essence, it is where there are two legal representatives and the couple sitting around a table. They sign what you call a participation agreement to stay out of court. So it takes the threat of the court away from the negotiations. And if you look at it from the perspective even of the legal representatives, they have an invested in the process because they want it to work. Because if it doesn't work, the same people can't engage them in future court contested proceedings. So really, I would urge anybody who's trying to
okay, so if I go in with Solicitor A into a collaborative law system, and you're my ex, and you're with Solicitor B, and then we end up, that falls, breaks down, whatever, A and B cannot represent either of us in court.
No.
So if they want to earn their crust, they have got to make it work in the collaborative process.
Exactly. So therefore they will work harder.
They will work harder.
There's no question about that. And it's really much more prevalent than people realise, particularly in South Dublin, down in Cork, in Wicklow. There are pockets of collaborative lawyers all over the place. There's no need for barristers either, so it's more cost effective also.
Yeah. One of the things I remember when we talked about this before was the notion that you had to park a lot of your grievances outside the door.
Yes.
That the essence of it was reaching an agreement, and particularly where there are children, that the fate of the children and all of this was paramount.
Yeah.
The well-being of the children.
Absolutely. I mean, the children are of paramount consideration, and, both parties have to bring their bona fides to the table. There has to be full financial transparency in relation to all issues. Otherwise, it's not going to work, Pat. But I think if people can try and be adult about it, I mean, there are celebrities like Guy and Madonna and, these people even availing of it. So, where there's huge money at stake. So it's very, very worthwhile looking at it as an option.
Is it hard for people to park their grievances outside the door?
I think it's very difficult, and obviously as family lawyers we always recommend personal counselling. The lawyer cannot take the role of a counsellor in relation to all of these issues, and we have to remember that it's like a grief. So if you know the Elizabeth Kubler-Ross grief stages, the denial, the anger, the bargaining, the depression, the acceptance, they go through all of these stages in a marital breakdown. I don't think people realise that. It's not, the factual legal aspect of a divorce or separation is only the small part of it. There are so many other issues going on.
Yeah. And do you find in the collaborative law process that sometimes there are eruptions and people have to be reminded, hang on, rules of the game here?
Yes, absolutely. And they can still fight over the Louise Kennedy glasses or what it may be. But, we don't judge people, and none of us know what we'd be like in that situation. So I suppose the lawyer who is a collaborative lawyer usually has a fairly good insight into themselves and how these things work.
What are the issues that have become more crucial given the recession, negative equity and so on? There was a time they were fighting over their possessions. Now they might be fighting over their debts. Oh,
they are, Pat, and it's extremely difficult for people. I mean, if you can imagine a situation where not alone are you in negative equity in your one property, but you're also separating from your wife or your husband, and you have 4 or 5 children, it's really awful for them. And the biggest issue, which has been going on really since 2009 or even 2010, is in relation to the banks not taking on board the indemnities that are put into court orders. So, for example, if there will be an indemnity put in place where one spouse, where they've transferred the family home over to the other spouse, and they indemnify them in relation to the outstanding mortgage, but the bank is ignoring that.
So can they ignore?
They can, and they are. Now, there are some repossession cases in the Master's Court where the Master has allowed the person rely on the indemnity, but this is a very common problem. So family lawyers need to say it's subject to the bank's consent. And I would even go one step further and to say that there is really no reality to couples embarking in a case unless they go into the lending institution before the court hearing and sit down with them and say, what is your view in relation to restructuring this loan, or in relation to trying to work a way around it? Because otherwise it's not worth the paper it's written on.
And Josepha, have you come across couples who end up being separated or even divorced but are stuck in the same house?
Absolutely, yeah. And I've talked about that before. Yeah, and that's where mediation has a very important role in terms of the rules of the game, and trying, and of course domestic abuse and addiction, all of these things go up in relation to that. So it's very tough for people, Pat.
And another question is about the in-camera rule. There has been a relaxing of the in-camera rule, and I presume that will continue if there's a new court. What does this relaxation mean? Because one of the things that people would feel most intrusive would be court reporters sitting there watching proceedings unfold about their family, about their separation.
And again, this is provided for in the Courts Bill 2013 also. And I would be of the view that there has to be a balance between full transparency and accountability for the family law courts, where heretofore there hasn't been, against protecting the anonymity, if you like, of the litigants. And I do think that there are some protections in place. For example, there's a 50,000 fine, I believe, for journalists, which has been proposed. And I think perhaps a prison sentence of 3 years if they, controvert that in any way. So there are protections in place.
All right, I have lots of questions coming in for you, and we will deal with those after this. Now, Josepha Madigan is with me, and we're talking about family law, and we have a number of questions for you if you're willing to take them. This first one: I'm a widow, but my partner is separated from his wife for over 25 years. They're both from Northern Ireland and are Presbyterian. Can he get a divorce in this jurisdiction even though she lives in the north? She would not accept a divorce on religious grounds.
Well, the Recognition of Foreign Divorces Act usually allows a divorce be accepted in this jurisdiction if either party is domiciled there. And on religious grounds, Pat, you can't stop somebody divorcing you on religious grounds.
You can't say, I'm not having it.
No, you can't. No, you can't.
So if he was to divorce here in this jurisdiction, presumably he would have to let the other party know, would he?
Oh, yes, he would. They would have to be served, out of the jurisdiction.
And therefore they could object to it? But it wouldn't hold any water?
No, it wouldn't. Ultimately, it wouldn't, no.
All right. Another question. My brother pays his maintenance every week, yet his ex doesn't show up with the child every week when she's meant to. He hasn't seen the child in months and can't get a date for Dolphin House till January. It's disgraceful. So yet another Christmas without his daughter, yet when he recently missed some payments, he was ordered to pay or get 3 months in prison. Yet she can go for months breaking the order and nothing happens to her. It's not fair for fathers. So if he fails a payment, he gets hammered. She doesn't live up to her side of the obligation, and she doesn't get hammered. And
actually, this is a common misperception because maintenance and access don't go hand in hand. They're not mutually exclusive.
You're not paying for access.
No, exactly. So the only statutory obligation actually on a father is to pay maintenance. It's not. You can't actually force a father to see his child. She does have a hearing date, or he does have a hearing date for January. That's unfortunately the system that we're stuck with. But there's
no way in which he can, because Christmas is coming. He won't see the child.
Well, no, and if she's the primary carer, no, and if they're unmarried and he's not a guardian. Obviously, he should apply for guardianship as well if he's not already a guardian, and that will help in relation to the access. But the maintenance, he will have to continue anyway, so that's a separate issue to the access. He will be entitled to access. The father's meant to supervise access, so he will be entitled to some access, but he will have to provide for access.
Even though he already has it under a court order.
Yeah, she's in contempt of court then. So that will be taken into account by the judge. There's no question about that.
This one: my fiancé and I split up some time back. She has made my life hell. I want to be my child's legal guardian. I'm rewriting my will now and wish to put her at the heart of it. If her mum wasn't here, have I the rights to take care of her? Can I be a guardian even if her mum does not agree?
Yes, I mean, there's two ways of getting guardianship for a father. One is by deed, which is on consent, and the other is to apply under the Guardianship of Infants Act 1964. So he just needs to go into the district court, make an application for guardianship. And, if he's a good father, he's not shirking from his responsibilities and he's doing his best to look after the child, there's absolutely no reason.
So
the courts are very disposed.
If the wife, who's the former fiancé rather, never married, even she is the primary carer, she cannot say no.
She can say no, Pat, but she can't withhold her consent, for no good reason. I mean, unless
she can try to prevent it.
She can try to prevent it, but I mean, at the end of the day, the courts are much more pro-fathers than I think people realise. And there's no reason why he shouldn't be appointed a guardian, so he'll have an equal say in the upbringing of his daughter over the years to come.
This one: with reference to family law, I would like to know how to get my ex-husband to pay maintenance as he now lives in the UK. We've been separated for 6 years now, and although I've tried through the legal aid system, nothing is happening.
There is a register for enforcement of maintenance over in England, so there's a central register, so it should be easily enforceable. So really, if she's not having any luck with her legal aid solicitor, although most of them are extremely competent, maybe she could talk to a private solicitor and get some proper advice in relation to it.
But the register is there.
But there is absolutely, yeah.
Can he be attached for his earnings over there?
Yes.
He can.
You can, at source, the way you can be here also.
Even though the person who's looking for the attachment is living in this jurisdiction?
No, it's enforceable over there also.
Enforceable over there. A question for your family law expert. My son is about to turn 18, still at school. He's now saying he wants to live with his father, even though I have full custody. Where do I stand in this situation?
Now, she doesn't state whether she's married or not to the father, because if she's married, both of them are technically joint custodians, although she might be the primary carer. The difficulty with a child that's age 18, he's an adult, he's really going to be free to make his decision, Pat, yeah. And if there was great difficulties in the context of a divorce or separation, you'd get a Section 47 report, etc., from an independent psychologist to advise in relation to the custody. But he's free to make his own decision, and that's very tough for her.
At 18, that's it?
Yes, really.
No control one way or the other.
Unless there's a very good reason why, if the father was abusing the child or something like that. But otherwise, no.
I'm having a nightmare with my ex-partner at the moment. I have an access order and guardianship, but she is refusing to allow me to see my children. I've been to Dolphin House twice in the last 3 weeks and have summoned her to court twice, but can't get a date until the 6th of January next year. The courts say this is all they can do. Also, every time she breaches the order, I report to my local police station and they tell me there's nothing they can do. Please help me. I'd love to hear what you have to say. That's
And actually, just a thought just occurred to me there, Pat, and also in relation to the earlier query you had. In the district court, domestic violence applications have to be commenced in the district court, but in relation to access and guardianship, you can bring those in the circuit court jurisdiction instead of the district court jurisdiction. So there is discretion there, and often you get a better hearing in the circuit court.
But how quickly could you get it?
It may cost you more. That's the only issue. You might get on quicker. And you might get a better hearing. I'm just saying, if there's frustration relating to the district court system, which is through no fault of the judges themselves, it's just the way it is, as I say. So we're hoping that this, I
mean, I know people in these marital breakdown situations or relationship breakdown situations can be very much at odds with each other, at each other's throats. But it does seem you have a system where courts hand down orders and then people just totally ignore them.
Mm-hmm. But they can't totally ignore them, Pat.
Well, this guy here saying, an access order and guardianship, and she just says no.
Well, I would recommend that he go to the circuit court in relation to it.
And what would they do for him?
You can't ignore court orders or be in contempt of court indefinitely. You can actually attach a committal to prison.
If you have 3 young children, and you're telling the former husband or the former partner to go take a jump, and ultimately it goes to the circuit court and the judge says, well, I'm committing you to the women's prison for a week or whatever for contempt. And then someone stands up and says, but this woman, her children, what will happen to them? Your man who's got guardianship rights maybe is not in a position to take them on. He's holding down a full-time job, blah, blah, blah. So
I appreciate that. And there's always
is she ever going to go to jail?
Well, there's always going to be mitigating circumstances. And the judges, obviously don't want to imprison somebody unnecessarily. And people will be allowed an opportunity to put their case to the court. But ultimately, if they're ignoring all contempt, they will go to prison.
You wonder if there's a case for kind of like a truancy service that they used to have. It's gone now for schools, I believe. But the old truancy officer would be going round, why haven't you turned up at school? I mean, is there a case for some service like that to back up the family courts? I mean, if I was a judge sitting in a family court, I feel like an awful idiot that I was handing down all of these orders and no one was paying a blind bit of notice to me.
I would say most people do take court orders very seriously because it has much impact as a criminal court order at the end of the day, and they don't realise that, and eventually they accept the fact that actually I cannot avoid this. But you really need to get a good lawyer. You really need to get, if you can't afford it, go to your legal aid board and get somebody to represent you in a robust way, I would say, and not to always be on the defensive. Go on the offensive and look for your rights. I mean, it's very important in terms of the extended family. It's not just in relation to the couple.
Yeah, often people don't want to be too robust because of the children. They don't want to be apparently fighting tooth and nail. Here's another one. I'm divorced as of May of this year. Last Wednesday, I received an email from my ex-husband saying he cannot sustain the agreed payments such as mortgage and child support. Do we now have to go back through the course again to come to a new arrangement?
Unfortunately, probably yes.
Because this would be more and more common, I would suspect. He would
have to give it, yes, and it is. He would probably have to bring a variation to maintenance proceedings in circumstances where he can no longer pay the monies that he had agreed. But obviously, a judge would only accept that if there was a significant change in circumstances. So you would have to swear an affidavit of means, which is basically a sworn, financial statement outlining your income, your assets, and your debts and liabilities. So it's not a case of simply saying, "Oh, I can't afford it," but you have to be able to prove that you can't afford it.
One of the situations in this jurisdiction, of course, is we don't have the final divorce.
Yes.
In other jurisdictions, a lump sum might be paid, or well, there's no offence here, there's no fault divorce here, but the one partner who's the economically viable one would borrow money even from a bank and say, there you are, there's the money, goodbye, and we are done with each other. That is not the case here.
No, and although there was a G&G case which was in 2011, the Supreme Court, which has now watertightened that. So, in other words, a full and final settlement clause now holds a lot more weight than it used to.
But it's still not necessarily. But it's still,
the word divorce is a bit of a misnomer, yes, and you can come in for the third bite of the cherry, but you can't come in willy-nilly, Pat. You have to,
Okay, but here's my question. What
I'm saying really is that it's not up to the judge to redistribute wealth. It's to make proper proper provision for the parties.
But here's what is prompted by that. Someone gets a divorce and agrees to make various payments and help with mortgage and blah, blah, blah. Then that person who is if you like, the breadwinner, be it male or female, goes off and marries somebody else. And now there isn't enough to go around to find a new family, to fund a new family and a new household. What happens in that situation?
Well, the judge will take all those factors into account.
But can he reduce then the amount that was originally given to the first party?
Conceivably.
Say there's more mouths to feed, and he goes off
everything is taken into account, Pat. And the earning capacity of the spouses, their income, their any disability, all of those things, the factors are taken into account.
Particularly when someone is receiving maintenance for him or herself from the wealthier
spousal maintenance, yeah. Well, I mean,
and suddenly he normally has another spouse and another set of kids, and he says to the original one, "Sorry, I can't afford to give you what I was giving you because I've now got a new family."
Yeah, but I mean, the court can give short shrift to that too. I mean, the judges are very savvy to tactical manoeuvres like that.
No, but I mean, if it's true,
but if it's true, then it's true. I mean, you can't get blood from a stone. So and spousal maintenance is child maintenance is one issue. Spousal maintenance is discretionary. It's not like in the States where alimony is, given all the time, more over one's lifetime. And judges may give wives, in particular, a moratorium in relation to earnings.
There's one very last one, very quickly. I'm a grandmother, sporadically see my grandchildren, but only on the whim of their mother. Can I go to court to see my grandchildren?
Yes, and there's a new grandparents bill coming in relation to that, Pat, where it'll be a one-tiered approach as opposed to the present two-tiered approach. Yes.
Very good. Josepha Madigan of Madigan Solicitors and Mediators. Very interesting session. I hope to have you back in a few weeks to answer some more questions. Josepha, thank you.
18 go.